Last time when we talked, I mentioned representing Kellogg in 2001, and I used Ernie the Keebler Elf as a representative of the intellectual property portfolio that was one of the factors that drove the decision for Kellogg to purchase Keebler. As I indicated, Kellogg paid $4.5 billion. Financial experts will typically place the value of an intellectual property portfolio at 1/3 or more, making Ernie a $1.5 billion elf. I raise it today specifically because we're talking about trademarks. Trademarks can be the most valuable part of your intellectual property portfolio. In this case, there were a number of trademarks, not just the Keebler Elves, but the trademark on their kitchen in the tree, the Cheez-Its brand, a number of other brands were part of and contributed to that $1.5 billion in valuation of the intellectual property portfolio. Some of the most valuable trademarks today, this was from a report done early this year based on 2020. Amazon, presently valued at $220 billion. That is just the trademark Amazon valued at that amount. Google, $159 billion. Apple, $140 billion. Microsoft, $117 billion. And Samsung at $94 billion. What contributes to these values? Number one, it gives these companies the potential for a higher selling price. If you have a product or service that the consuming public identifies according to your brand and they're attracted to your brand, you can charge higher selling prices. You see that a lot, for example, with Apple products. They can get a premium because of their trademark Apple and the recognition of that by consumers with regard to what consumers are seeking. Number two, protect your market share. Same argument applies. Brands, trademarks help you protect your market share. Number three, additional revenue streams. Like all intellectual property, you can sell your trademarks, your brand names. You can also license those to others to use to sell your products. A good example of that is, for example, Gucci. They recently reached a deal with REI, which is a store that sells outdoor products, to start selling backpacks and other types of gear that REI sells with the Gucci trademark on it. Number four, it protects your business reputation. That's what trademarks are all about, your business reputation. And they protect you from others trying to get close and use your goodwill to benefit them in trying to sell their products. I'll talk about that more as we go on. And number five, as we've already talked about, greater business value. All right, quick overview today. We're going to be talking about intellectual property and its value. Number two, we're going to be talking about how every business has intellectual property. In particular, every business has at least one trademark. That IP includes trademarks, copyrights, patents, and trade secrets. As I indicated today, we're going to be talking mainly about trademarks. And then lastly, as I discussed last time, and I'll only briefly review it again today, is the three-step system, a simple system for protecting your business from surprises and protecting your business's intellectual property. Briefly, that is what I refer to as the recipe for success. The three steps are: number one, recognize; two, collect; and three, protect. The recognize step is where you recognize at a 40,000-foot level your business has intellectual property. It is valuable and you should protect it. One of the key pieces of intellectual property in your portfolio are your trademarks. The others are copyrights, patents, and trade secrets. Just as an indication of what's coming in the next 2 weeks, I'll be talking about copyrights next Tuesday and patents the Tuesday after that. I'll give you some more information on that as we proceed. A company that used the three-step process to great success was Trinex, started by Chuck and Jay Truen. Chuck and Jay started out in the lawn and garden maintenance business, turned that into a lawn and garden retail business. Through both of those businesses, they learned a lot about intellectual property and, more importantly, the value of it, and they wanted a system to make sure they protected it. They came to me with the idea of getting patent protection because they had come up with a great new invention that would revolutionize the salt spreader industry. And that was that yellow plastic hopper on the back of that vehicle. Prior to Trinex, these were always made out of metal of some kind. They decided they could make them out of plastic, but that came with a lot of challenges. And they had figured out a way to make it work and wanted to get patent protection. But also we needed to focus on getting them good, strong trademarks for their business. They wanted to use another trademark, which actually ended up being owned by a company out of Canada. So then they set their sights on getting a better trademark, which we investigated to make sure there would be no problems, and also advised them on how to get a good, strong trademark. As I indicated previously, Trinex did very well. They recently sold that business, and one of the driving factors in the decision to purchase was the intellectual property portfolio, and a highlight in that portfolio, what were the trademarks. There was Trinex, there was also SweepX, TurfX, SnowX, and a number of other sub-brands that were all very well recognized by the consuming public and very valuable to the company that purchased Trinex. So what does it take to get a good, strong trademark? Trademark strength's determined on a scale from weak to strong. Way over on the weak side, off the chart, can't be protected as trademarks, are generic words. Those are common words for common things like clock for clock. A weak trademark would be one that is descriptive. It can be protected, but it's weak. And a descriptive trademark is something that describes a function, feature, or the product itself, like Sharp for TV. A suggestive trademark is one that suggests a function, feature, or the product itself, like, for example, Airbus. A very strong trademark would be one that is arbitrary. And that's a common word used in an uncommon way, like Apple for computers. And then the strongest of all trademarks are coined trademarks, like Exxon. These are words that are just made up. They never existed before. And they're very strong because others can't get close to them and have a good argument why they need to name their product or services something that's close and confusing to your trademark when that trademark never existed previously. Trinex is a coined mark. It's a word that never existed before, therefore extremely strong and very easy to protect, almost self-policing. Another example of an arbitrary mark would be Amazon.com, suggestive, FedEx, descriptive, Kleenex. Now, there are a couple important things that you have to know to keep your trademarks good, strong, and to keep them growing. One thing is that trademarks always have to be used. If you intentionally stop using a trademark, then you'll lose your rights to that trademark. Someone else could actually pick that trademark up and use it if you intentionally stop using it. So it's important to always use it, and it's important to keep evidence of how you're using it. So if you never need to show it, and you do if you federally register, you have that evidence in hand. An important thing also to know with regard to use is a weak trade or a descriptive trademark, a weak trademark can become very, very strong through use. For example, FedEx is a very strong trademark, and it became strong because of its continued use and recognition by consumers, and over time it got stronger. But it's also important to know that trademarks have to be used properly. And that is, they always need to be used as an adjective and never a verb or a noun. If you begin To use your trademark as a verb or noun, you can actually lose all rights to it. It can slide all the way back down the scale and become generic, which has happened to a number of trademarks through time. Examples of those would be thermos, once an incredibly valuable trademark, wasn't used properly. It was used as an adjective or a noun to describe the product, and it was lost forever. Aspirin. Escalator was once a very valuable trademark. Even dumpster was a valuable trademark owned by the Dempster brothers, but used improperly and lost forever. A trademark right now that is worth billions of dollars and is not being used properly is the mark Google. To use it correctly as an adjective, you would say Google search engine. Using it improperly as a noun, we check Google. As a verb, let's Google that question. That's using it improperly, and over time will weaken that very valuable trademark if action's not taken to correct that in the minds of consumers. I mentioned that it's important to keep your mark and protect your mark from others getting close to it. It's also equally important when you're picking a trademark, not to pick a trademark that's going to get you into trouble with other trademark owners, get you a threatening letter, force you to change your trademark, or even end up in a lawsuit. Here's an example. Magnolia of Oakland County is a marijuana distribution company. They decided to name one of their strains of marijuana Girl Scout cookies. Well, you can imagine who wasn't happy about that. And you have to ask yourself, what were they smoking? An interesting twist to that is Danielle Lee. She's a Girl Scout selling Girl Scout cookies. And if you look over her shoulder, her right shoulder, you will see a green cross. That's a marijuana dispensary. She decided to set up her business in front of it. She sold 117 boxes of cookies in less than 2 hours. Being an entrepreneur, her trademark was satisfy your munchies. What's important with this example is you need to be careful in picking your trademark. I recently represented a company who had been using a trademark for 8 years. It was called Principal Group. After 8 years, they were sued by an international bank called the Principal Financial Group. And ultimately, they're faced with, do I litigate this and spend $250,000 plus in defending myself, or do I change my company name, get everything rebranded, get re-recognized by my consumers, also probably costing them in the hundreds of thousands of dollars to do. That would not have happened if they would have had a search done to see what the risks were in adopting the name Principal Group, because the Financial Principal Group would have shown up in that search and they would have been advised, it's not a good choice, pick something new. But after 8 years, they're in a real serious problem. Common law trademarks versus federally registered trademarks. I've mentioned use. In the United States, in order to have a trademark, you have to use it. That's a requirement. And you have to continually use it to keep it. But that's all you need to do to have a trademark. You could just use it and not register it at all, but it is advisable to get it registered. You can register at the state level, but it's even better to register at the federal level with the United States Patent and Trademark Office. Let me give you an example why. This is the very first Burger King ever opened in Illinois. Burger King started in 1953 in Florida. They opened their first restaurant, quickly began to open other restaurants in neighboring states. One of the requirements to file for federal registration is you have to use your trademark in interstate commerce. Today, with the internet, that's pretty easy in most situations. Once Burger King began to serve food to interstate customers. Even more importantly, once they entered another state with a restaurant, they're clearly in interstate commerce and could register for trademark protection. For some reason, opening in 1953, they didn't attempt to register until 1961. And that same year that they got their trademark registration, they also decided to open their first Burger King in Illinois. This Burger King was the first one, but it's not the one owned by the national chain. This Burger King was owned by Gene and Betty Hoots and was opened in 1957, 4 years before Burger King came to Illinois. The Hoots didn't want the national chain in the state, so they filed suit. And the judge agreed with the Hoots that they had common law trademark rights because they were the first to use their trademark, but those rights are limited to the geographic area in which they used their mark and where they may begin to expand in the future. And the judge arbitrarily decided that that was a 25-mile radius around Mattoon, Illinois, and that's as far as their trademark extended, allowing the national chain to open restaurants throughout Illinois outside of that 25-mile radius. What's important about this is if Burger King had registered before 1957, when the Hoots began to use the Burger King name on their restaurant, they would have been able to force them to change that name because trademark registration with the United States Patent and Trademark Office extends throughout the United States and cuts off all latecomers, one of the most important rights you get in registering with the USPTO. I mentioned use a number of times. It's also important to know that you need to use your mark consistently. Federal Express is a mark that's still used today by the company, but back in 1991-94, they began to change how they were identified to consumers as FedEx. So if they completely stopped using Federal Express, arguably that would be available. FedEx, the image that you see here, or the logo, changed as well. Now, 1994 to present, it's the blue and orange FedEx and both upper and lower case, differentiated from the other style logo. Now, if these logos had been registered, the second one, if it had been registered with the United States Patent and Trademark Office, they could not renew that if they weren't using it. In order to renew your trademarks every 10 years, the logo has to appear the same or you aren't entitled to renew. So again, it's just an important point on use and continued use. All right, let's talk about some issues that can arise with trademarks and picking a trademark for use. Here's an interesting case. Victoria's Secret, in an effort to protect their trademark and in order to continue to have a very strong trademark, they actively search to make sure others aren't using any marks that are the same or confusingly similar. And if they find someone and advise them that they feel there's a problem, they expect them to change that mark or get involved in litigation. They found a company in Kentucky, actually, the story behind this, a colonel in the Army was upset that at the time called Victor's Secret, an adult novelty shop, was using that name and he thought it was offensive in view of Victoria's Secret, and he reported this use to them. Victoria's Secret sent Victor's Secret a letter telling them to cease and desist using that trademark. Victor, his actual name is Victor Mosley, wanting to continue to use his first name in his store, decided to change his name to Victor's Little Secret. Victoria's Secret advised him that wasn't enough. He said he didn't really care, and Victoria's Secret sued him, which resulted in a 10-year lawsuit that went to the Supreme Court once. Was the result of that decision, which was in Victor's Little Secret's favor. Congress changed the law with regard to famous trademarks, and ultimately Victoria's Secret was successful after a second round of cases, and now it's called Kathy's Little Secret after Victor's wife. One thing you can say about Victor Mosley is he's a determined character. But this shows you the seriousness of protecting your trademark, while at the same time it shows you how picking a trademark can really get you into trouble and get you into a lot of expense if you don't research these names before choosing them. Here's another example, Variety Stores. Variety Stores is a company that sells grill-related products. They name their product Backyard. Walmart decided to name its grill-related products Backyard as well. They were threatened with suit by Variety Stores. Walmart did not respond to Variety Stores' request to change their name. They got sued, and the jury in North Carolina originally awarded Backyard or Variety Stores around $35 million for the infringement. Walmart appealed, and the jury came back after that appeal and awarded Variety Stores $95.5 million for the infringement. That case is again on appeal, but it illustrates the value of these trademarks, and it illustrates the need to protect, and it illustrates the issues you can get into if you choose trademarks that are close to your competition, trademarks that would confuse consumers. That's the legal test for trademark infringement. Talking about grills, here's a trademarked grill. You probably recognize this as a Weber grill if you do much backyard grilling. It also shows that in addition to words, in addition to logos, products themselves can be protected by trademark. Here's another Weber product that's protected. This is a gas grill that they sell. Interesting thing on this grill, you can see the dotted lines. That's telling the trademark office and telling anybody that is interested in the scope of this trademark that doesn't form part of the trademark. The legs and handles do not form part of the trademark. It's only what is in solid lines. Other things that can be trademarked, you may recognize this product. It is a logo, but really it's a picture of an individual. He is on the Jack Daniels bottle. Jack Daniels has gone to great effort to protect just about everything on that bottle. The shape, the picture of Jack Daniel, the black label, the number 7, all protected by trademarks. Other things that can be protected by trademark, they're difficult to get, but valuable if you can get them, and that is color. Dawson Tire is a client who began selling these tires. They're plastic tires, and they're in this very bright green. If you go to Nebraska, other areas where there's huge farming going on, you will see fields with watering structures all having black tires, except when Dawson tires are being used, and they're bright green. They stand out remarkably well, and we were able to get federal registration for the appearance of that tire in green. A single color is difficult to get. The Patent and Trademark Office is more likely to give you protection if you have more than one color. An example of that's John Deere with the green and yellow color. Another single color is UPS. Their brown trucks are protected. The white and turquoise of the Tiffany box is also protected, the color of it. All right, brief overview of trademarks. Get a clearance opinion. Make sure your trademark's available and strong. Use your trademark and keep evidence of use. You may be called upon to do this to prove you own the trademark and that you are using it. If you file for federal registration, as I mentioned earlier, you have to renew it the first time within the 5th and 6th years, thereafter every 10 years. And to do that, you have to prove you're using the trademark. Register your trademark in the United States. As I mentioned, you don't have to. You can rely upon common law rights, but federal registration gives you protection throughout the United States against any latecomers. The other nice benefit of federal registration is if anybody's looking to pick a trademark, the first thing you do is go to the USPTO and check and see if anybody has registered that trademark and if the goods and services that are represented by that trademark are similar to yours. So it's a very nice self-policing option or benefit that you receive from federal registration. Registering in other countries is absolutely critical. In most other countries, they don't rely on first use. It's whoever files first gets trademark registration and gets trademark rights. If you're doing business in other countries or you're looking to do business in other countries, make sure your trademarks are registered, particularly before you enter those countries. I've had many cases where trademarks are hijacked either by individuals that are related to the company, like distributors or even total strangers. And when we want to get our mark registered, they hold it hostage and we have to pay enormous amounts of money to get our own trademark back or try to fight for that, which costs a lot of money. To prevent that, you register before you go into those countries and make sure that any countries you're in now, you have those registrations. And then lastly, police your trademarks. Make sure your trademarks aren't being used by others or anybody else using something confusingly similar to your mark. Previously, I talked about collecting. Just remind you again, you can quickly train your employees to collect your intellectual property. They need to ask themselves 2 questions. Is it important to your business? If the question is yes, the second question is, would you rather your competitors not have it? Again, if the answer is yes, it is probably protectable. This applies to trademarks as well. Look at the marks you're using on your products, and if they're important to your business and you don't want your competition to have them, I strongly suggest that you look at getting federal trademark protection. Protect is the 3rd step of the recipe for success. That's where you get together with counsel. As I mentioned before, quarterly is best. If you have a huge portfolio, monthly will work better. You review everything that you've collected through the previous quarter. You discuss your protection options with counsel at that time. And then lastly, review new product or service launches. This applies as well to trademarks. You want to be careful when you launch products that whatever trademark you're using on them, however you're identifying them, that is available. I've shown this before. This is just a quick, easy way to provide everybody with a snapshot of a company's entire intellectual property portfolio. The first one is a utility patent, the second a design patent. Important point with regard to design patents, they're good for 15 years. During that period, you are more than likely developing very strong trademark protection for that product and can register. An interesting product that I just investigated is Lego. Lego has utility patents, design patents, copyrights, and trademarks on every one of their figurines, and it builds a web of protection for that company and for those products. The last two on this snapshot are trademarks of, this happens to be Trinex from a number of years ago. Those are trademarks that they had in addition to their main trademarks. But this, what I refer to as a status sheet, shows the status of all intellectual property, what's coming due, what needs to be done, where we might have gaps that need to be filled. That makes these protection meetings a lot faster because all questions can be answered during that meeting. And as I've said before, they should be should be able to be done within about an hour. Unfortunately, I have a confession to make. I use the trademark, the IP guy. I've used it now for several years in preparing for a conference earlier this year. In fact, I did some searching, and while I was searching some companies' information, I decided to look to see if anybody had ever attempted to register IP guy. To my horror, the IP guys was a trademark that had been filed by a law firm in Connecticut that does intellectual property work. Frankly, this is how I felt when I saw that. It was shocking and disappointing because as the cobbler doesn't, as the cobbler's children don't have shoes, the IP lawyers don't protect their own trademarks and take their own advice. This happens to be my granddaughter in an indication of something she wanted, she wasn't getting. What happens now, and the reason I was so upset, is I found it luckily after it was allowed, and now I had to file an opposition to that. When you attempt to register a trademark with the United States Patent and Trademark Office, after you get it allowed by the examiner, the USPTO publishes it for opposition to let anybody who might be hurt by that registration to let the PTO know and oppose the registration to try to prevent it from being registered. It's not cheap, and it could totally have been avoided if I would have registered my trademark long ago when I would have advised any client to register the trademark. But that's a good reason why you should register your trademarks, and is a good reason to have the protection phase of the three-step process, because it helps you identify these loopholes and encourages you to get things done. As before, I offered and will offer again a IP review. We will collect your IP, analyze your website, discuss your future plans, identify gaps in your portfolio, and create an action plan going forward. As I've indicated, these can typically be $1,500 to $2,500 if you go to a law firm to do those. I am willing to do it, offer to do it for $500, give you the plan going forward. If we decide to represent you, I will apply that $500 as a credit towards any legal work that we do for you. If you're interested, please just send me an email at bill@ipguide.com. That's the easiest way to get a hold of me. Want to close as I closed last week with Scrub Daddy. Scrub Daddy I use as an illustration of the value of intellectual property. Today I'm going to use it to illustrate the value of trademarks. This is their packaging. The product itself is a sponge with a smiley face and hair cut into those serrated sections. The name Scrub Daddy is their trademark. The appearance of that product is a trademark. The packaging itself is a trademark. The colors they use are trademarks. In fact, the company Scrub Daddy has 54 trademarks protecting this product and related products, and those trademarks help them to keep competition away from their product. and allow them to have a recent evaluation of $390 million for a sponge product. Want to just promote next week's talk. Next week, I'll be talking about copyrights. The trolls are really out to get you. More and more, we're seeing copyright trolls come after not only businesses, but individuals for cutting and pasting images. I'll be talking about that, as well as some other information regarding trademarks. That's next Tuesday, May 18th at 11 a.m. Thank you. Appreciate you attending. Again, if you have any questions, give me a call, 248-433-7381, or you can email me at bill@ipguide.com.